Okay, Assalamualaikum warahmatullahi wabarakatuh. Can you hear me? Okay. Okay, we are from group 4. We will be presenting about the question regarding section 411 and section 34 of the Penal Code. So I will read the question. So these are our group member. Hazim and Nizam are best friends since primary school in their village in Kedah. Now, both of them are working in Kuala Lumpur and have their own families. One day, Hazim has told Nizam that he had just bought a second-hand Toyota Alphard for the comfort of his family. Happy to hear this news, Nizam went to Hazim's house and together drove the car around Kuala Lumpur. Around 11 p.m., while going through a roadblock by the police in Jalan Ampang, they were both arrested. And finally, both of them were charged at the Ampang Magistrate Court. The charge against them as follows: that you were together on 22nd June 2022 at about 11 p.m. in Jalan Ampang in the district of Ampang and in the state of Selangor with fraudulent intent to have stolen property, namely a Toyota Alphard MPV car, registration number VCD 1111 belonging to Ahmad Kasim bin Dollah, with reason to believe that the property is stolen property, and thus you have committed an offence punishable under section 411 of the Penal Code and read together with section 34 of the same code. Hazim and Nizam pleaded not guilty and asked to be tried. Among the reasons given by Hazim that he bought the vehicle from ABC Company through mudah.com. However, after making payment of 10,000 ringgit until today, Hazim still does not have any ownership document for the vehicle from ABC Company, which is Toyota Alphard. And when contacted, the company apparently didn't exist, and the officer in charge could not also be contacted. So, based on the police record, Hazim was found guilty in 2010 of snatching a pedestrian handbag at a traffic light in Pandan Indah. At the same time, Hazim also failed to bring any evidence that he had made a payment of 10,000 ringgit to the company. So, question 1. What are the
presenter Azamuddin
yes,
and the rest of the presenter of this group just highlight briefly on the principle, the elements, or whatever factors on the evidence that you want to stress out, and then apply it straight away to the case.
okay.
I don't want you to elaborate further on this one decided case, this appeal court case, and then what are the principle because of the time constraint. Please, Azamuddin.
Okay, Tuan. Okay, what are the evidence to support prosecution case against Hazim and Nizam? So the issue is whether there is a material evidence to support prosecution case against Hazim and Nizam under Evidence Act 1950. So we refer to the section 3 of Evidence Act about the documentary evidence, and also we refer to the Tay Long Siak against PP and also Yek Nipo against PP, which in this case the court stated that the prosecution must produce the stolen vehicle registration card and also who owned the vehicle. And we apply to the current case, the prosecution shall produce documentary evidence, which are the registration card of the Toyota Alphard MPV car belong to the Ahmad Kasih Ahmad. And also the prosecution shall produce vehicle ownership card. So there is a difference between registration card and also vehicle ownership card. So the prosecution shall also tender police report.
Presenter.
Yes.
There are difference between vehicle registration card and also vehicle ownership card.
Yes. Oh.
I don't think so because kad pendaftaran kenderaan is no more in practice by JPJ. Now we are using only sijil pemilikan kenderaan.
Oh. Okay, I understand.
I think this one, the kad pendaftaran kenderaan is before 2000. I think 2015 and above, yeah, and before
Oh,
that, 2015 and before that, we are using kad pendaftaran kenderaan. But after 2015, if I'm not mistaken, we are using only sijil pemilikan kenderaan, ya.
I see,
Sijil,
I see.
okay, ya.
Okay, okay, Tuan. Okay, that's all from me for documentary evidence.
And police report, ya.
Yes, police report to
Ya.
support the registration card, registration, vehicle
So,
ownership card.
so in summary, for documentary evidence, you have summarized into two lah.
Yes,
Vehicle ownership card and also police report, yeah. Police
yeah.
report by who?
By Ahmad Kasim.
Ahmad Kasim.
Yes.
Okay.
We move to the next presenter to present about oral evidence. Thank you.
Okay, thank you, Azam. So basically, if we can define the oral evidence, it is statement which the court permit or require to be made by witness in relation to matter of fact under inquiry. This is by Section 3 of the Evidence Act, and also we can look at Section 59 of the Evidence Act, and also Section 60, where the oral evidence will be direct, and also Section 118 of the Evidence Act. Yes.
Haziq,
Yes.
I think you better, you have mic?
Yes.
Yeah, okay, I think you better put your mic near to your mouth. And then can you, I think you are using fan, kan?
Sorry.
Your fan tu boleh tak you hadapkan ke tempat lain because it's disturb your ni apa ni, volume, your voice, it's not clear.
Okay. Shall I repeat? Okay.
Okay.
Okay. Basically, the prosecution also can rely on the oral evidence. So basically, oral evidence can be defined as all statement which the court permit or require to be made by witness in relation to matter of fact under inquiry. This is based on Section 3 of Evidence Act 1950. We also can look into the Section 59 of Evidence Act 1950, also Section 60, and also Section 118 of the Evidence Act.
Okay.
Okay, move to the next slide. So the case we look is the case of public prosecutor against one.
Okay, can you proceed with the application of the principle of oral evidence to our recent case? Okay.
So in our situation, the prosecution can call Ahmad Kasim as the witness, who is the complainant in the present case, to the court to give his testimony in order to prove the car that was stolen was his. And he can directly prove the car was his through the police report has been made that his car was stolen. Also giving the testimony, the model of the car, registration number, and so on. Which was the same with the Hazim and Nizam during the arrest. So the prosecution can also call the police officer who received the police report from Ahmad Qasim to testify the detail of the car stolen. And also the prosecution also can use the police officer testimony who was in charge for arresting both Hazim and Nizam during the roadblock to give the testimony that Hazim and Nizam was in the car which was stolen. So the prosecution also can bring an officer from the JPJ as a witness to give testimony in order to prove the identity of stolen car and also its registered owner. The registration card, which contain model, engine, and test number, with the Hazim and Nizam during the arrested police. I think
good.
that's all for the oral evidence. So we move to the next presenter.
Thank you very much, Haziq. Now let's move on to circumstantial evidence. So the third issue that we found here is whether circumstantial evidence is the suitable medium in supporting prosecution case against Hazim and Nizam. Therefore, we found two relevant sections here, which is Section 5 and Section 6 of Evidence Act 1950. Section 5 basically said that evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and of no others. Therefore, if such evidence is relevant, then it is admissible. Next, Section 6 of Evidence Act 1950 states that facts which thought not in issue are so connected with a fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and place.
Okay, please apply these two sections to the recent case.
Okay. To apply in this case, among the circumstantial evidence which may be tendered, the first, the fact that Hazim does not have any ownership document for the car and other related documents such as grants, insurance, car usage guide, and the others. And then the second circumstantial evidence is the fact that Hazim bought the car at much cheaper, which is too cheap from the market, which around 10,000 ringgit. And then the third one, the company did not exist and not registered under the registrar of companies. And then during the prosecution, Hazim failed to contact the office in charge of the company that he bought the car, and then he also could not bring evidence to prove the payment of 10,000 ringgit to the company. Therefore, it can be presumed that the car is stolen and that Hazim knew that it is indeed a stolen property.
Okay, good.
That's all for my part. Thank you. Over to you, Sufia.
Okay.
Okay, we move on to the second question. Do you think prosecution can prove prima facie case against Hazim and Nizam? Next. So the relevant provisions discussing about prima facie is section 180 of the Criminal Procedure Code. I will straight away jump to subsection 4, in which it states that a prima facie case is made out against the accused where the prosecution has adduced credible evidence proving each ingredient of the offence, which if unrebutted or unexplained would warrant a conviction. Thus, next, in order for the prosecution to prove a prima facie case against Hazim and Nizam, every element of the offence under section 411 and to read together with 34 must be proved. Next. Okay. The offence of dishonestly receiving stolen property has been explained in section 411 of the Penal Code, which I shall summarize in the case of Banta Singh against public prosecutor. So in this case, the onus is under section 411, the court stated that the onus is on the prosecution to prove that first, the property was stolen property. Second, the accused received or retained the property. Third, he did so dishonestly. And lastly, he knew or had reason to believe that the property was stolen property. Next.
Okay, apply this case to our recent case.
Okay. As for the first element, we must prove that the prosecution must prove that the Toyota Alphard MPV car is a stolen property. So next. Okay. Again, next. I shall not. Okay. As for the application, the first element that the car is a stolen property can be proved by the testimony given by Ahmad Kasim, the owner of the car, that his car has been stolen, and the fact that Ahmad Kasim has made a police report as to the loss of his car, and the registration card of the car which contains a particular of the car, and the fact that the car bore the same registration number as Ahmad Kasim's car, and the fact that Ahmad Kasim does not have any ownership document to prove his ownership of the car, and his failure to bring evidence of the payment, and also the testimony of the JPJ officer to prove the identity of the stolen car. All these facts can be used and can be tendered by the prosecution to prove the first element against Hazim and Nizam, that is the MPV car, the Alphard MPV car is a stolen property. Next.
Okay.
Okay, the second element is the accused must have received or retained the said car. So in the case of public prosecutor against Wan Muhammad Rahim, Wan Muhammad Zim, in this case, when stopped by the police, the respondent was riding the motorcycle. So he had the physical capacity to drive the car in whatever manner he pleased. So it cannot be said that he was merely physically present or in the physical proximity to the vehicle. And thus, the respondent had sole control, custody, and dominion over the car. On the other hand, the pillion rider cannot be said to have had possession of the motorcycle, as it was the respondent who was riding the motorcycle. Next. Okay. So the application from the case in our situation, as against Hazim, the car was allegedly purchased by him. And the car, therefore, we can safely presume that the car was at all material time kept and parked at Hazim's house before the arrest, and that Hazim was the one who holds the car keys and not Nizam. And at the time of the arrest or roadblock, we can infer that Hazim was the one who driving the car, while Nazim was the passenger, and thus Hazim has the sole control, custody, and dominion over the said car, and Nizam has neither control, custody, or dominion over the said car. Thus, the second ingredient of the offense can be proved against Hazim, but not against Nizam.
Okay.
Next. As for the third elements of the offense is the accused must have received, retained the car dishonestly. So dishonestly here, as has been defined in section 24 of the Penal Code, to means whoever does anything with the intention to cause wrongful gain to one person or wrongful loss to another is said to have dishonest intention. And wrongful gain and wrongful loss has been further defined in section 23 of the Penal Code. The wrongful gain is gain by unlawful means of property to which the person gaining it is not legally entitled to it, while wrongful loss is a loss and where a Raza Litono bin Ropai against the public prosecutor. So in this case, from the case, the motorcycle was found to be in the appellant's possession 3 days after the theft. And it was reasonable to conclude that such possession was soon after the theft and that this possession was dishonest when he could not account satisfactorily for the possessions of the motorcycle. This is because the investigation revealed that he had exchanged the motorcycle with his wristwatch, which was valued only at 100 ringgit as compared to the motorcycle, which was valued at 4,800 ringgit. So by having the possession in the said motorcycle through that kind of mode of exchange, that is by paying a much cheaper price, so the appellant had intended to cause wrongful gain to himself and wrongful loss to the complainant, i.e. the owner of the motorcycle.
How you want to apply this authority in this case to our recent case?
So in this present case, the fact that Hazim had alleged that he had bought 10,000 ringgit shows that the car was purchased for a sum which is significantly below the price of below the market price, because Toyota Alphard is usually priced at second-hand Toyota Alphard is priced at 20,000 and above. So the fact that therefore it is reasonable to conclude that he has received or retained the said car dishonestly as he had intended to cause wrongful gain to himself by paying only 10,000 ringgit for a second-hand Alphard car, and he had intended to cause wrongful loss to Ahmad Kasim. Thus, the third element is established against Hazim. Okay, next. As against Nizam, since the second element earlier, which I have explained earlier, cannot be proved against Nizam, so there shall be no requirement to establish the third element, as he could not act dishonestly to retain the car if he had not received or retained the said car in the first place. So the third element is not applicable against Nizam.
So what happened to Nizam?
As for Nizam, at the end, we will conclude that there is no prima facie case against him, but this will further explained by my friend.
Okay, thank you.
All right. So next, as for the last element, the accused must have knowledge or has reason to believe that the said car is stolen property. So reason to believe under section 26 of the Penal Code, a person
Okay,
is...
I think for this particular sub element, you just focus on has reason to believe, yeah, because I believe Hazim has no knowledge about the stolen car. So you just focus on has reason to believe.
So the last element is we must prove that Hazim or Nizam has reason to believe that the said car is a stolen property.
How to apply this?
We refer to the case of, Azam? Okay. I refer to the case of Samad bin Khamis and another against public prosecutor. So in this case, the court held that the accused has reason to believe that that the oil was stolen as the price were unreasonable. Here, it is obvious that the appellant was acting dishonestly as he purchased the oil at less than half of the market value and that he knew that the oil was sold to him at a very cheap price.
Okay, in Hazim's case?
in Hazim case, Azam next.
Oh, okay. Okay, Azam, please, Azam.
Okay. So this is the Samad case. So we refer to Samad case to apply in Hazim's situation.
Situation. Okay.
The fact that Hazim alleged to have purchased the car at 10,000 ringgit, which is below the market price. So it can be inferred that he has reason to believe that the car is stolen property.
Okay.
As for Nizam,
Presenter. Hold on, yeah. How you want to prove to the court that 10,000 is actually below market price?
to prove the market price of the car, we have to make research on the model of the car, on the model of the car, and the year it was produced. But in this case, since we are confined to the facts given, so we can only presume based on the facts given, based on the general facts given, that 1000K is cheap. It's below market.
Pandai menjawab. Very good. I like this girl. Okay.
Okay.
Yeah,
As for
basically, okay. Common sense. If you are the prosecutor for this particular case, is there any necessity for your team to subpoena or to bring any expert people or expert evidence to let's say for car, for house we have valuer, for land we have valuer, so for car we also have valuer, because if you want to make a comparison with all the website, for example mudah.com, all this apa ni, tukar.com, apa lagi ni yang all the related car punya ni, Poltan and all other website. Sometimes we need, do you still need to bring physical people, expert to the court to value that particular car?
in my opinion, as a prosecution, I think it is necessary for prosecution to produce expert evidence in order to bring a more reliable evidence from the expert. But I think as a reasonable man, not necessarily an expert, people who involved in business like car dealer, they can actually be brought before the court since they are familiar with the market price. So not necessarily.
Good.
Yeah.
Okay. Next presenter, please.
Thank you.
Okay, thank you. Lupa nama. Siapa nama tadi? Siapa nama presenter tadi?
Sufia, Tuan.
Sufia.
Sufia.
Okay, Sufia. Nice voice, eh?
Terima kasih, Tuan.
Boleh baca berita. Okay, proceed. Next presenter.
Tuan, I cannot open my camera. My line is not well.
It's okay, so long I can hear your voice clearly. Your voice tu serak-serak basah. Kalau nyanyi sedap ni.
Thank you. So next to the presumption of possession. So the presumption of possession, upon the proof of presumption of possession, we can prove the fourth element that has been mentioned by Sophia just now. So section 114 of the Evidence Act 1950 provides that the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common cause of natural events, human conduct, and public and private business in their relation to the facts of the particular case. So we can also relate to illustration A to section 114 of the Evidence Act 1950, which the court may presume that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen, unless he can account for his possession. Next. So I will refer to the case of public prosecutor against Hong Ahwat. In this case, the court mentioned section 411 of the Penal Code, which require that the theft was committed and certain articles were stolen, and that the stolen articles were recovered from the possession of the accused have to be established by direct evidence. So if these two facts are established and the recovery from the possession of the accused is recent, it is open to the court to presume under illustration A of section 114 that the person is either the thief or has received the article. Next,
okay, hold on, presenter. Yeah? What are the relevance of section 114 illustration A to section 411 Penal Code?
So illustration for 114 of illustration A is to establish the presumption of possession, which is mentioned in section 411 of the Penal Code.
Okay, can you read again public prosecutor against Hong Ahwat decision? Under section 411 of the Penal Code, two facts, namely, one, that a theft was committed and certain article was stolen, and that the stolen article were recovered from the possession of the accused have to be established by direct evidence. So these two element is regarding to theft, a different section in Penal Code. Section 411 is not theft. Jawablah. Jangan takut-takut, jawab. Apa? Saya nak uji dia ni. Why?
So to relate with, I think this case should not be used here. Sekejap. For when that was committed, cyber stolen.
No, actually, presumption of possession under section 114 is relevant to section 411 of Penal Code. Menerima harta curi orang, memiliki harta curi. So, presumption of possession is relevant to show that the accused received a stolen property. How to prove? So, section 114, illustration A. That is the formula. Faham? Okay. Okay, apply. Please apply.
Okay, so there are cases that require two elements in proving the presumption of possession.
Okay, property stolen. Okay, agreed. Kita semua tahu dah. Oh, next element. Apa dia?
Next element is a person is possession of the property. So public prosecutor against Song Ahwat define what is possession.
Apa dia?
Legal capacity to deal with the thing as we like, to the exclusion of everyone, and a determination to exercise that physical power on one's own behalf. So we can say that the possession must be conscious and intelligent possession and not merely the physical presence of the accused in proximity or even in close proximity to the accused, to the object.
Okay, apply to our case?
Yeah, to apply to our case, so Hazim had told Nizam that he bought the car for the comfort of his family, and then Nizam went to his house together to drive the car around Kuala Lumpur. Here we can say that the car is kept or parked at Hazim's house and that he was the one who held the car's key. Thus, we can safely say that at night when they were stopped and arrested, Hazim was the one who drove the car since the car was allegedly his, while Nazim was the passenger. And that Hazim has the sole control, custody, and dominion over the car and has intelligent and conscious possession of the said car. And for it also cannot be said that he was merely physically present or in physical proximity to the car. Thus, the second ingredient to invoke presumption under section 114A of the Penal Code has been established against Hazim. However, against Nizam, the car was allegedly Hazim's. So because Nizam only came to Hazim's house to see the car, and during the roadblock, we can infer that Nizam was the passenger as the car was Hazim's, and he would be driving it. Nizam, on the other hand, has no control, custody, no dominion of the car, and has no conscious possession of the car as the car was placed at Hazim's place. So hence, the elements of possession cannot be proved against Nizam, and there is no evidence to show that Nizam has possession of the car unless him being the passenger when Hazim was driving it around Kuala Lumpur. Thus, the second element could not be established against Nizam.
Okay.
Okay.
So, if no evidence against Nizam, what you should do as a prosecution team?
So, if there is no evidence against Nizam, we will try to prosecute him to to see whether he has the joint liability.
Joint liability,
Joint liability.
jointly liable for what offense? Because
For
you can't prove any case against him. So as a prosecution team, what you should do to the court?
maybe I'll call him as witness instead of
Okay,
prosecuting.
that is a good suggestion. But before that, should you drop the charges against Nazim? So Nizam.
Withdraw. So withdraw against Nizam because there's
Oh,
no case.
okay, good. Withdraw the charges against Nizam and offered him as a witness for the prosecution team.
Yeah.
Agree? Okay. Good. Okay, please proceed. Next presenter.
Still me.
Oh, okay, still you. Okay. Please, Arifa.
Okay, so the last one is this was soon after the theft.
Yeah. This part is very crucial. This was soon after the theft. Okay. How you want to apply? What is the definition of soon? So soon. What is the definition of soon?
Based on the case, public prosecutor against Song Ahwat and PP against Wan Muhammad Rahim, Wan Muhammad Zain, what I can conclude is that the definition of soon after varied according to the nature of the article and how quickly it can pass from hand to hand. So
one day, okay, we can agree. One day still so soon, kan? 1 week, 2 weeks, 1 month, 3 months. Is there any time frame to define what is the meaning of soon after the theft?
Based on the case had not stipulated any precise period, but as we can see in the case of PP against Wan Muhammad Rahim, it involves motorcycle, and the court held that for the time lapse of 17 days, it is not so long as to preclude the application of the presumption.
Okay. Never mind. This should be the question in your criminal class, not in evidence. Definition, all these element. Kan? Anyway, please proceed how you want to apply this element to our recent case.
So to apply, the concerned property is an MPV car. So from the facts, the date in which the car has been stolen from its owner, Ahmad Kasim, and the date in which the police report has been lodged were not stated. And that based on the decided cases, the term soon after depends on the nature of the article and how quickly it can pass from hand to hand. So since a car cannot be easily disposed of, a period which exceeds more than 2 weeks is not so long as to preclude the application of the presumption. So since Hazim and Nizam were arrested while going through a police roadblock, we can safely assume that the theft or the recovery of the stolen car from the possession of Hazim is recent, and hence it does not preclude the application of the presumption. Hence, the last element has been established against Hazim. As the element of possession could not be proved against Nizam, this requirement need not to be established against Nizam.
Okay.
Okay, next. Okay, this is the last one. So the case is to account for his possession. We can refer to the case of PP against Wan Muhammad Rahim, in which once presumption is applied, the evidentiary burden would have shifted to the respondent merely to account for his possession of the vehicle, resulting in defense being called. So application section 114A of the Evidence Act does not have the effect of imputing guilt on the part of the respondent to the charge of theft at this stage. That must be a question to be determined on the totality of the evidence after the respondent chooses to account or otherwise for his possession. So
Okay. We understand about this. So how we want to apply this element to our recent case?
So to apply, as all of the elements of presumption has been proved against Hazim, so the burden would have shifted to Hazim merely to account for his possession of the car. So based on the facts, it was found that after making payment of 10,000 ringgit Until today, Hazim still does not have any ownership document for the vehicle from the ABC company. When contacted, company apparently did not exist, and the officer in charge would also not be contacted, could also not be contacted. And at the same time, Hazim also failed to bring any evidence to prove the payment of 10,000 ringgit to the company, and in the absence of the evidence to prove his claims that he bought the car from ABC company through mudah.com, we can conclude that Hazim could not and fails to account for his possession of the car. And hence, Hazim fails to rebut the presumption by his failure to adduce evidence to account for his possession of the said car. The court may presume that Hazim, who is in possession of stolen car soon after the theft, is either the thief or has received the car knowing it to be stolen.
Okay.
Okay, lastly, as for Nizam, as the stolen property has been proved, it cannot be established that Nizam was in possession of the car, nor he had gained the possession dishonestly.
Okay, so no case against Nizam, yeah?
Yeah, no case against Nizam.
Okay, good. Okay, question 3.
Bismillahirrahmanirrahim. Assalamualaikum. Thank you.
Waalaikumsalam.
All right. I and Amin Sharif will answer question 3. What are the defenses available that can be raised by Hazim and Nizam? So,
okay, presenter Hakim, yeah. Yes. As we know, the prosecution team does not want to proceed against Nizam. They are dropping charges against Nizam, so you can focus on the defense available to Hazim only.
All right, Tuan Faisal. But before that, for the purpose of presentation, my friend Amin Sharif did prepare for defense available for Nizam if the prosecution prosecute Nizam. Shall he present?
Never mind. Presenter apa ni? Muhammad Syaril ya, your friend. No?
Yes, Amin Sharif.
Amin Syaril, after you. He will present after you or before?
After me.
Okay, never mind. I have question for him. Never mind, proceed Hazim. Apa ni Abdul Hakim?
Right, thank you, Tuan. Let's have a look on the next slide. Right, so for the purpose of understanding or to invoke defense for Hazim, we will first need to have a look on section 411 of Penal Code. So from this provision, there are two subject matter we need to observe. The first one is whether Hazim dishonestly received or retained the stolen property, and second, whether Hazim have reason to believe that the said property, the Toyota Alphard, is the second-hand Toyota Alphard is a stolen property. So let's have a look on the next slide. So in our argument, we put forward that Hazim have no knowledge or have reason to believe that the car bought by him from mudah.com is a stolen property. So first of all, we need to understand the definition of section of reason to believe that is provided under section 26 of Penal Code. A person is said to have reason to believe a thing if he has sufficient cause to believe that thing, but not otherwise. Or in other words, the person had referred to any circumstances to show that the subject matter exists, or for example, in the case of stolen property, there is any circumstantial evidence that shows that or give a presumption that it is indeed a stolen property. And then
Abdul Hakim,
yes,
what is your argument, your submission to say that Hazim has no reason to believe this car is a stolen car?
Should I explain the case or just apply based on what I
just apply straight away?
Right.
Apply. Okay,
so let's have a look on the application. So we submit that Hazim have reason to believe that the second hand car is not a stolen car, because the first one, Hazim was not informed directly or indirectly from ABC company that the property sold against him is a stolen property. And second, even the property was brought under market value, it is not enough to show that Hazim have knowledge that the MPV is a stolen property, since he is purchasing a second-hand property, which is normally have any defects and was used for a long time. We did refer to the case Tan Se Joy and public prosecutor, where in this case the court highlight that mere suspicion on the accused, where he do not have any receipt of the payment for purchasing a watch, cannot allow for his conviction. In other words, merely suspicion cannot allow the conviction against the accused.
Okay.
And then we also argue that there may have negligence on behalf of Hazim for not insisting from ABC company on the ownership document when making the purchase of the property. Hazim also have no knowledge that the MPV have was stolen property before and after purchasing the property. If he was informed by ABC company or any other person during before or during purchasing the second-hand company, there is sufficient. It is sufficient to show that he did have knowledge. However, in this present case, Hazim was not informed and did not acquire any knowledge that the property is indeed a stolen property. Let's have a look on the next.
Okay, Hakim.
Yes.
Okay. Reverse back to the slide before this. Okay. Okay. First point. Yeah. Hazim was not informed directly or indirectly from ABC company that the property sold to him is a stolen property. Yeah. How you want to prove this? When the fact of the case, we cannot contention also unlocated. So how you want to prove this? If you are acting as a defense lawyer to Hazim in the stage of defense, call for the defense and not under prima facie. Let's say court make a decision, there's a prima facie case, then Hazim was called for the defense. So how you want to prove this?
First, we will have a look on the circumstances of Hazim when he is using the car. We can see that he is driving the car around KL, even though there is a roadblock. It shows that he is confident that the car is indeed it's not a stolen car, and he also give cooperation to the officer at during the police roadblock. If he indeed had purchased a stolen car, he perhaps will be more will avoid the roadblock and run away from the police.
Okay, good, very good. Okay, next slide or next presenter.
Amit, do you mind if you to present on this part?
I think it's better you like him.
Come on, Amir, you can do it, please.
Okay, basically, Rahim, my name is Sharif. So, as for the element of dishonesty, we can refer back to the section. No. As the element of dishonesty, we can refer back to the previous case that was mentioned by the presenter before, which is was mentioned in the section 24 of the Penal Code. Whereas, in order to prove the dishonesty, it is important in order to prove the element of theft under the section 411, it is important to prove the mens rea, which is there is the dishonesty intention, and also the the actus reus, which is the property is stolen, and also the person know or has the reason to believe that the property is stolen. So Hakim has
Why
stated in the
why
slide.
you say Amir, why you
Yeah.
say Hazim has no dishonest intention?
If we can refer back to the present, if we can refer back to the problem, we can see that his act, especially because if we can see, if I will refer to the case that I put in my slide, which is in the case of public prosecutor against Rajendran, anak lelaki Nagalingam, which is in this case, the court mentioned that if the prosecution failed to prove the elements which is from provided under the 411, the prosecution will fail. So if we can refer back to the case of Hazim just now, the fact that he has the courage, or he has the ability to bring his friend come over from outside of his house and ask him to drive him around the KL. So the fact that he did not tamper anything to the car, and also he also give a full cooperation with the police officer, and also he answered all the question. He also did not lie about the transaction with the ABC company, shows that he did not act in dishonesty, as we can refer back to the section 24 of the Penal Code, Tuan.
Okay, good. So how you want to prove 10,000 ringgit is reasonable price?
So as for the 10,000 ringgit, I will refer back to Mr. Hakim.
Oh, boleh pass baton. Bagus.
Right, thank you, Amir. In my submission, I highlight that it is reasonable for the second-hand Toyota to be a cheap price, referring to this fact that it is a second-hand car. So we can presume that it was used for a long time and may require regular maintenance. And talking about a second-hand car, Toyota Alphard car have various type of Toyota Alphard car. We can also refer to when the date the car was produced and the history of maintenance. Perhaps there is we can presume from that fact that the car will easily go in, have perhaps aircon problem or alignment, tire alignment problem, which can increase the probability that the car is require regular maintenance and to be cheap.
Okay, you stated there, furthermore, Hazim is not acting dishonestly in possessing the car, since he bought the car through a valid contract from ABC company, even he did not receive an ownership document. Yeah, how you want to prove the ownership document is actually exists, or the contract is actually exists, when you can't locate ABC company or the contact person? How you want to prove?
As for this fact, we to show that whether to show that the ABC that Hazim indeed purchased the said property, we can refer to his previous texts and messages with the representative from ABC company to show
Good.
that.
Okay, good. Actually, that helped me. This case actually handled by me for my client, and we are actually using the text communication. Text communication between my client and the salesman. So Alhamdulillah, my client was released, or actually the charges has been dropped. There's no prima facie case against my client. So very good, Hakim. You can think to critically, analytically. Yeah. Any more, presenter?
I think there is no more explanation unless you wish to hear defense from on behalf of Nizam.
No, I don't want it because no case against Nizam. Prosecution team already dropped the case against Nizam. So what for? We want to proceed. Even for academic purpose, I think all of you already understand about the status of Nizam. Yeah. Okay. Any question? Any queries that you want to ask me? I believe next week is the last week for us. But tentatively, according to the faculty, this week is the last week, kan? But due to my time constraint, I extend to another week, the 5th week. So group 5 from this TLB 3 and 4, TLB 3 and 4, Abdul Hakim? Yeah.
Yes.
Group 5. Group 5. Any representative from Group 5 present today? Group 5?
Yes, sir.
Yes. Nur Abida.
Ya, Tuan.
You nak soalan apa minggu depan? Nur Abida. Nur Abida. Diam terus.
Nak soalan yang mudah, Tuan.
Nak soalan siapa ni? Adila. Nak soalan apa, Adila?
Ada pilihan ke?
Tak ada, saya tanya dia. Nak soalan apa? Saya tak buat lagi soalannya. Saya nak buat lepas ni. You nak kes jenayah civil ataupun jenayah syariah? Bincang dulu lah tu, ya Allah. Okay.
Itu pun boleh juga, Tuan.
Alah, dah ini grup yang kelima, tak boleh nak jawab. Okay. Never mind. Let me think about it and let me thoroughly think what are the best scenario problematic question for group 5, because group 5 ni marking dia agak kena lebih sikit lah tak macam group 1. Group 1 saya agak loose. Group 2 pun loose. Group 5 ni saya agak strict sikit.
Tapi nak exam dah, Tuan.
Tak kira lah. Exam bila? Next week, study week kan? Okay. Baik. Okay, kalau dah tak ada apa-apa, kita tamatkan. We end our session today by reciting surah Wal-As and tasbih kafarah. A'udzubillahi minasyaitonirrajim. Bismillahirrahmanirrahim. Wal-'asr innal insana lafi khusrin illa allazina amanu wa 'amilus solihat wa tawasaw bil haqq wa tawasaw bis sabr. Subhanakallahumma wa bihamdik asyhadu an la ilaha illa anta astaghfiruka wa atubu ilaik. Okay, class. Thank you for your participation.